the Constituent Assembly. So you had to have a recommendation of the Constituent Assembly before you could efface 370. That's what the Constitution makers themselves thought in 1950. And that operated till 6th of August. How could it change?
But how long would the tenure of the Constituent Assembly of the state be?
7 years. 6
Sorry?
years, 51 to 57.
So therefore, with the end of the 7 years,
Yeah.
the very institution of the Constituent Assembly of the state lapses. Then there's no Constituent
Absolutely
Assembly
right.
left.
Absolutely.
But then what happens with the
This is
proviso?
the point, Mullah.
But then what happens with the proviso then?
This is exactly the point, Mullah. This is exactly the point. Mullah, the in between 51 and 57, the Constituent Assembly could take that decision.
But thereafter,
Mullah, there's no question because they formed the. Well, take the Constitution.
what happens after the Constituent Assembly has come to an end? Because no Constituent Assembly can have an indefinite life.
That's precisely the point, Mullah. That is my point. The Constituent Assembly in India, when it drafted the Constitution, can't have a life after the Constitution is framed.
No, but equally, the proviso to clause 3 refers to the recommendation of the Constituent Assembly of the state.
Yes.
The substantive provision says that the President may by a notification declare that the article shall cease to be operative.
Yes.
Right? Now, the only safeguard is that before the President does so, the recommendation of the Constituent Assembly of the state has to be taken.
Yes.
Now, what happens at a point of time where the Constituent Assembly of the state ceases to exist?
But that's the point. The President can't issue such a notification.
According to after 57, it can't be done at all.
No, after 57, it can't.
Then
happens-
clause 3,
That's what
exactly.
that
What
is why
happens
it was
to temporary used in the
that is
article?
why the temporary provision.
No, but that's
because Manoj, this was,
one more fundamental issue, which is that notwithstanding the fact that the proviso ceases to operate, clause 3, the substantive part, continues to hold the field.
no, it is dependent on the proviso.
No.
With respect, no, Manoj. With respect, any proviso.
If the
Manoj,
proviso, I mean, there are ways in which you can construe a proviso, but if the proviso ceases to operate by virtue of the fact that the tenure of the Constituent Assembly of the state has ceased to exist, surely the substantive part of 3 still continues to remain.
Kindly see the scheme of 370, Manoj, with the greatest respect. Kindly see the scheme of 370. On the 4 items, Manoj, that is defense, communications, external affairs and ancillary matters, Manoj, the consultation of the state is necessary under 370. For all other matters, the concurrence of the state is necessary. So can you say you do away with the concurrence? And then the third thing is, if you want to abrogate 370, then or amend it, you have to get the recommendation of the Constituent Assembly.
So long
what
as
is
it
put
exists.
to me,
So long as it exists.
Marat, I'm sorry, Marat, this is the point, Marat. That's why I said initially, the Constituent Assembly, Marat, has served its term when a constitution is framed.
So in which case, then what happens is if your construction is right, 370, which is essentially a transitional provision, assumes the character of a permanent position.
No, it is a
by
transition.
virtue of the fact that there is no Constituent Assembly of the state after 1957.
Absolutely, absolutely. It's a transitional provision between 1951 and 1957 when the Constituent Assembly could take that decision. Which was left to the people of Kashmir.
So according to you, after 57, Article 3 has become redundant.
Whereas Constituent Assembly, even in the context of Constitution of India, is redundant.
So there is
You
no
can't revive a Constituent Assembly.
there is no method according to you
Yes.
by which either with consultation assembly or
Yes,
otherwise
yes.
can 370 at all be abrogated.
Malaz, the amendment that is made ultimately, they convert the legislature into a Constituent
That's a
Assembly.
different matter, right?
No, but that tells you their understanding. Please appreciate that. It's their understanding of the Constitution.
Civil, there are 2 separate aspects. One is interpretation of clause 3 of Article 370 and the proviso to that.
Yes,
The second part is what the amendments have been made and how do you interpret.
yes. Well, I can't hear your lordship. Yes.
One is interpretation of clause 3 to
Right,
Article
right.
370 has to be done independently of the amendments.
Right.
So your contention is the proviso specifically applies, and unless the proviso is resorted to, and it cannot be resorted to after 1957, clause 3 will not be applicable. That's your sub and subset.
Yes, absolutely. That's absolutely right, Mullah. That's absolutely right. Whereas, just as clause 2(3) has worked itself out. Mullah, the point is, why was this clause put in 1950? What? Because in 1950 they said we'll have a constituent assembly. See the constituent assembly debates, it will be made clear.
51 to 50 is there.
To accept your submission, we'll have to postulate that clause 3 becomes a sort of a constitutional article which falls into desuetude after 7 years.
Yes, absolutely. Because,
How can that be?
Whereas
Clause 3 still continues to survive.
whereas
The limitation on clause 3 may cease to operate.
kindly see 369. Continues, Mullah. Kindly see 369. Temporary powers to Parliament to make laws. That's the part. Part 21, Mullah.
See, 371 begins with a non-obstante clause. It
Yeah.
overrides the entirety of the constitution.
Absolutely, Mullah.
But
So does
clause 3 contains a non-obstante clause which overrides clause 1 as well.
Yes.
So therefore, notwithstanding, because 371 makes special provisions in relation to the state of Jammu and Kashmir.
Correct.
But 373 has a non-obstante provision which overrides the non-obstante clause in clause 1.
For that period, Manoj, we are not disputing that. What your lordships is putting to me, there is a structure in place that was envisaged by the constitution in Manoj 1950. At that time, there was no constituent assembly. Why did they mention constituent assembly? Need not have mentioned it. Kindly look at it from that point of view. What was the reason to mention constituent assembly in 370 when it was not even in place? They could have said government of Jammu and Kashmir. Why did the constitution makers, Manoj, include the term constituent assembly in 3? Because they knew that the constituent assembly will frame a
Actually,
constitution.
there was no limited, the acceptance of sovereignty of the Dominion of India was complete. They didn't say in the instrument of accession that we accept the sovereignty of the Union of India for some limited purposes. They accepted the sovereignty for all intents and purposes. That acceptance of sovereignty was complete, but they reserved certain rights to themselves over certain legislative subjects. So in that sense, the accession was complete. The acceptance of sovereignty was complete. Now, consistent with that, therefore, it said that in clause 3, that the Union of India would have, the President of India would have the right to abrogate Article 370. It conditioned that subject to
Not the Union of India, but it's on the recommendation of the Constituent Assembly. Not Union of India has no right to till it is recommended. The word is recommendation of the Constituent Assembly. Then they can exercise that right. That's how you interpret a proviso. You can't say that they have the right sovereign, forget the proviso, even the recommendation of the Constituent Assembly, because it doesn't exist. Then 368 2 proviso also goes, Maras. Therefore, the reason is simple, Maras. The genesis of it was the fact that in 370 itself, it was mentioned that the Constituent Assembly has a role to play in the abrogation of 370. Otherwise, if your lordship says it had no role to play, there was no need for 370 sub-article 3. And look at the concurrence power. Even those powers were of no relevance thereafter because the Constitution of Jammu and Kashmir was in place. Therefore, there was no need for concurrence anymore. Because now you have a Constitution of the Jammu and Kashmir. So that also became odious. You have to see, Malad, the historical perspective in the context of which Jammu and Kashmir ultimately signed the instrument of accession. Nobody disputes whether they are integrated into India, but subjected to a constitutional provision.
Therefore, the submission is that once the period stipulated in the proviso to clause 3 had come to an end,
Yes.
the power under clause 3 itself came to an end.
Because it's no longer alive. The Constituent Assembly, like in India, Malas, can, for example, today Today, Malaj, there can't be a provision in the Constitution of India with reference to a Constituent Assembly, because the Constituent Assembly has worked itself out. It has formed the Constitution. Now, if it is decided that they would abrogate 370, the Constituent Assembly would have said, we abrogate 370. Which is why it was a temporary provision. Not because of the fact that under as a Union of India, it was
Oh, Mr.
deemed to be a
Sibal-
temporary. How could it be?
Sibal, sorry, interrupting you at this stage. It